Professor Szilay. It's my time now to play with the presenter. Oops. Oh yeah, it works. So, honorable, okay, he said it should be more loud. Honorable professors, gentlemen and ladies, esteemed guests, one of the most important milestones of accession to the EU was the definition of its constitutional basis, during which a constitutional amendment determined the division of competencies between the EU and Hungary, which also served as the basis for the integration of EU law to Hungarian legal system. Hungarian public law scholars were relatively slow in addressing legal issues related to the European integration, during which sovereignty issues were the most prominent. The Constitution as the basis for sovereignty and the rule of law sets out the framework for exercise of power and hence for legislation. However, European integration is changing traditional ideas about the state and the law, with obvious implications for the place and role of constitutions that do not recognize other sovereign over themselves. So it is affecting the fundamental issues of sovereignty, and therefore there was a need to amend our constitution too. Even with all this, the question of whether accession requires a constitutional amendment was a contentious issue in Hungary. The question was practically decided by the Constitutional Court with decision in 1998 on the constitutionality of certain provisions of the association agreement. The decision reflected the situation before the accession, naturally, so that it did not raise a number of questions, for example, the constitutionality of EU law after accession, but it did state that the source of the exercise of public power subject to democratic legitimacy must be public power under the Constitution, and that subjection to foreign law, decision called it foreign law, requires constitutional authorization. This decision became the reference point for the amendment of the Constitution, which was finally adopted in 2002. You can see the text on the slide. Since then, the so-called integration clause has been part of the Constitution. The amendment was intended to ensure coherence between the Treaty of Accession and our Constitution. The starting point was that the Constitution creates the possibility for the Treaty of Accession to be enforced in Hungary. The funding treaties of the European Union will ultimately be binding on the basis of the Constitution's mandate, and therefore the Constitution remains the basis of law in Hungary. As regards the exercise of sovereignty after accession, some public affairs will be conducted jointly with the other member states of the European Union or through the institutions of the European Union in accordance with the provisions of an international treaty ratified and proclaimed on the basis of Constitution. The integration clause does not provide for the relationship between EU law and national law, nor for the question of EU law becoming national law. During the preparation for the amendment, several ideas have been put forward to address this issue. These included the inclusion of, in the Constitution of a provision stating that participation in the European Union as a member state gives effect to EU law in accordance with founding treaties and the principles deriving from them. A further opinion was that no reference should be made at the constitutional level to the principles governing the application of EU law. It was also considered that the act proclaiming the Treaty of Accession would reflect the primacy of EU law and the obligation of the legislator to interpret national law into conformity with EU law. It was also argued that the Constitution contains a to the primacy of EU law without limiting the Constitutional Court powers in a way what is compatible with EU law. During the preparation of the constitutional amendment, The amendment proposal would have originally included a reference to EU law and other acquis of the European Union, but this would have meant an explicit recognition of the autonomy of EU law and its primacy over the Constitution, and therefore this provision was finally not included in the submitted proposal. The failure to clarify with EU law resulted in an open situation. From the side of the legislator, the application of the law is carried out in a national framework through a system of national institutions, the regulating principle, which is constitutionality, but at the same time they have to interpret the law in an EU compliant way, and the courts have to set aside national legislation or judicial decisions that violate EU law. However, by not containing explicit provisions on EU law into the Constitution did not raise its primacy on the constitutional level either. If this had been the case, the conflict of national law with EU law would have resulted in unconstitutionality, but this was not the case, and the Constitutional Court has also consistently avoided answering this question. In the first couple of years, the Constitutional Court consistently avoided answering this question and only examined the constitutionality of the legislation implementing EU law without examining the interpretation of EU law. In several cases, it has explicitly stressed that it has not examined the validity of the directive in question or the adequacy of its implementation. The Constitutional Court has also consistently avoided the use of the word sovereignty in these decisions. In this period, the court mostly found that it lacked competence concerning EU law aspects, or that the conflict of norms reigns in relation to EU law was not a constitutional issue at all. It is not that there were no opinions on this issue in the debates, since in the concurring or dissenting opinions there were occasional references to this question, to the question of applicability and interpretation of EU law and the existence of competence in this area, but these were not supported by the majority. In relation to agricultural subsidies, the court did not go as far, or practically did go as far as to interpret the relevant EU regulation in 2010, but here too it focused mainly on legal certainty when examining the relevant Hungarian law. From that time onwards, a cautious interpretation of EU law was made, but still no assessment on the relationship between the two legal systems was made. On the fourth day after signing the Lisbon Treaty in Hungary, it was promulgated by the Parliament. The President of the Republic did not veto its constitutionality. It was not debated by public law experts, and only a few petitions were filed to Constitutional Court too, raising the issue of the infringement of the country's sovereignty. The Constitutional Court decided the issue 2 years later. Although it established its competence to examine treaties, amending the founding and amending treaties, it also ruled that its decision could not have any effect on the commitments arising from EU membership. According to the Constitutional Court, the transfer of sovereignty has been carried out to the necessary extent, as the Lisbon Treaty has not fundamentally changed the European Union. It provides for a wider scope of control for parliaments than before by applying the principles of subsidiarity and proportionality, and it also provides for the possibility of proceedings before the Court of Justice. The question is whether the same conclusions can be drawn 12 years later. This is the golden question. With the adoption and entry into force of the fundamental law, Hungary now has a very different constitution with a strong identity-building emphasis, what we were talking about last time in our workshop. And, this constitution has guided the Constitutional Court to emphasize national specificities in its practice and to identify and protect legal institutions that have developed organically over history and are part of our constitutional culture. Professor Varga will talk about the consequences of all of this. Thank you very much for your kind attention.
Just rewrote my text.
As usual.
Don't forget.
So, honorable professors, ladies and gentlemen, dear guests, I try to continue from the point where Lilla stopped. So we Hungarians used to think about ourselves that throughout of our history, Hungary had been a state governed by its own constitutional laws and customs. Later, this was understood as a rule of law, which has been harmed only under countries' foreign occupations and during some dictatorial regimes imposed on Hungary by foreign powers. For our country, the change of regime of 1990s meant not only a return to our national and historical constitutional traditions, but also meant the adoption of new approaches and a novel vocabulary from the West. Starting at this crossroad, the Constitutional Court has opted for such a conception of rule of law that is usually characterized by an overemphasis on legal certainty, on the formal rule of law, and here the formal is underlined and highlighted. So the formal rule of law was the main character of the interpretation of the Constitution in the first 20 years after transition. The Constitutional Court ruled that this transition had taken place on the basis of legality. This was the core point of this interpretation. And when interpreting and applying the rule of law, the law enforcement bodies and other authorities of the state acting under the fundamental law, and this is the last decade of the Hungarian constitutional development, have to have regard to a number of other circumstances. One of them is that Hungary is a member state of the European Union, thus it should apply where is binding the EU law. In the absence of a specific legislation uniformly applicable, the Hungarian courts may not disregard the national legal provisions in force. Neither the European Union's law nor the fundamental law empowers the national courts to do so. On the contrary, according to Article R, Section 4, we don't have, but once we will create a new presentation. So according to Article R, Section 4 of the fundamental law, all bodies of the state, including the courts, have a duty to protect Hungary's constitutional identity and its Christian culture. Therefore, the constitutional dialogue in the European Court of Justice is not based on the absolute and unconditional primacy of the EU law. The Constitutional Court may examine, and has already examined, whether the EU institutions have exceeded the limits of the exercise of their powers laid down in the relevant provisions of the treaties. In its decision 22 of 2016, the Constitutional Court has set several limits to the implementation of EU acts that go beyond the scope of the conferred or of jointly exercised powers. The Constitutional Court has stated that on the basis of a motion to that effect, It could examine whether the joint exercise of powers infringes human dignity and other fundamental rights of Hungary's sovereignty and its identity based on its historical constitution. The decision introduced a new, previously unknown limit on the exercise of shared competence in the constitutional dialogue of Hungary by formulating, practically by copy-pasting the term from France, the term of constitutional identity. There was a concurring opinion, especially I was the author of that concurring opinion, attached to the decision, which tried to clarify the legal nature of Hungary's constitutional identity. The point of this opinion was that in the case of Hungary, national identity is particularly inseparable from constitutional identity. The fundamental values that constitute our identity have been established throughout our historical development and the historical development of the Constitution, and the nation has always adhered to them. The values that constitute the country's identity are legal facts, underlined again, that cannot be renounced either by an international treaty or by an amendment to fundamental law. The only way to deprive Hungary of these values would be to deprive of its sovereignty. That is why Hungary's accession to the European Union could not result in Hungary's renouncing its sovereignty or Hungary's declaring its cessation. The founding treaties only allowed for the joint exercise of certain competencies, and in relation to them, any further joint exercise of competencies must be presumed to be respecting the maintenance of Hungary's sovereignty. This was a new presumption, that time only mine, that when we signed the accession treaty, we maintained Hungary's sovereignty, and this should be taken into consideration when the EU law of Hungarian constitution is interpreted. In the absence of a specific competence conferred, the Union does not have the power to adopt legal acts that have binding force to the member states. Such ultra vires acts would disregard the principles governing the exercise of shared competencies as laid down in Articles 4 and 5 of the Treaty on European Union and in Article E, Section 2 of the Fundamental Law, including the principles of proportionality and subsidiarity, thus bypassing the limits of competence in short. The implementation of ultra vires acts in domestic law would violate Article B, Section 1 of our fundamental law, according to which Hungary is an independent democratic state governed by the rule of law. Therefore, all state bodies are obliged to act against such ultra vires acts in accordance with the requirement of the protection of sovereignty and constitutional identity. This approach in 2016 of the concurring reasoning was too strong for the majority of the court. But the latest addition to the constitutional dialogue in decision number 32 of 2021 from last year changed a bit the position of the Constitutional Court regarding to this nature of constitutional identity. Its significance lies in the fact that the Constitutional Court this time was not reluctant to use the ultra vires argument against EU acts adopted in the absence of the Union's competence. The conclusion of the former dissenting opinion attached to the 2016 decision has been included now in the operative part of this decision. Furthermore, the new decision clearly considers constitutional identity as a limit of the joint exercise of powers. The firm stance of the Constitutional Court, of course, is not without precedent. The decision refers to a number of Constitutional Court decisions from France, Poland, Germany, Czech Republic, and Spain, whereby national constitutional courts examine whether the exercise of EU powers is in conformity with the constitutional rules of the member states. The Constitutional Court has confirmed that the elements of population, language, history, and cultural traditions as the achievements of our historical constitution listed in the documents defining the struggle of a consolidated sovereignty are part of the country's constitutional identity. In this context, the Constitutional Court referred to the 7th Amendment to the Fundamental Law, according to which the joint exercise of powers may not restrict Hungary's inalienable right to dispose of its territorial unity, population, form of government, and state organization. Moreover, the 7th Amendment explicitly builds on Article 4, Section 2 of the Treaty on European Union, which states that the Union shall respect the national identities of the member states, including their political and constitutional organization. At the morning session, I mentioned the answer of the Luxembourg Court to this position. As such, a right of disposition in part of Hungary's constitutional identity as a historical constitutional achievement, it is the task of the Constitutional Court to set limits to the exercise of shared powers and to ensure the exercise of the right disposition of Hungary. However, this may be done only exceptionally if the exercise of powers conferred on them in a manifest manner, or if the exercise of shared competencies is only superficial in such a way that it manifestly does not ensure the effective implementation of EU law. In short, the Constitutional Court silently created a Hungarian set of eternity clauses by interpretation of the Constitution. What is interesting that if we look from a larger perspective, we see that there are some very, very common parts of the German, Czech, Croatian, and Hungarian, as we heard today, position of the Constitutional Court. Not so often bit, and it's expected that even the interpretation, even the speaking of the Constitutional Court should be more loud, not less loud. Why I think that it's not only a strange coincidence. I think that the reason is that the law, as in Europe we understand law, is a cultural product. If you want, is a cultural value. But this cultural value is very, very European. Its own cultural value, because in other parts of the world, of course, law exists. But law means mostly a tool, an instrument of keeping peace in the society. Practically is much more based on criminal law, or as we used to say in a general way, public law. But the European thinking is based on the civil law thinking. We don't want only to restrain, we don't want only to punish, but we look for the day after. So this is the European law and the European understanding of the law. In this context, of course, the role of the court is to solve the problem, not to announce ex cathedra very, very strange political statements. And this is why, as I see, every constitutional court is reluctant to use this ultra vires tool against the competence very often, because it's a bit strange from the judicial way of thinking. So this is what comes out for me from the morning session and what I was thinking during the lunch break. Thank you very much for your attention, and I'm very interested what is the approach of the other countries about this problem. Thank you very much.